Welcome back. I am attorney Nicholas Hicks, and this is part 2 of our debt elimination series. First of all, the information that I'm going to provide you today is for informational purposes only. It is not designed to be legal advice. It's not intended to be legal advice. You should consult with an attorney licensed to practice in this state to see how the information I'm giving you may apply to your particular circumstances. Now, the last time that we left off, we spent quite a bit of time debunking the myths and the misinformation surrounding debt elimination, or what the law refers to as bankruptcy. Now, there are a number of what we call chapters of bankruptcy, kinds of bankruptcies, and which chapter you use depends on your situation, who you are. Are you a business? Are you primarily consumer? Are you a farmer? Are you a corporation? But for most of us, that is non-business consumers, the two primary chapters of bankruptcy, or kinds of bankruptcy, are referred to as Chapter 7 bankruptcy and Chapter 13 bankruptcy. Now, the primary difference between the two is that Chapter 7 is referred to as a liquidation, a complete liquidation. That is, that you can eliminate 100% of all of your unsecured debt. Unsecured debt meaning that there is no collateral that secures the debt, like a house secures a mortgage, or an automobile secures the automobile loan. And it's secured because, obviously, if the mortgage isn't paid, they can foreclose and take the house. If the car note isn't paid, they can repossess the automobile. This is what's known as secured debt. Unsecured debt, obviously, are things like credit cards or hospital bills or personal loans that there is nothing for the lender to take back from you if the loan or debt isn't paid. So Chapter 7 allows you to eliminate 100% of that unsecured debt. Chapter 13, on the other hand, allows you to eliminate a portion sometimes of that debt. You may repay only pennies on the dollar, or in some instances you may pay 100% of everything back, but it gives you certain protections from creditors who may be foreclosing on your home or attempting to repossess your automobile, etc. So why would somebody file Chapter 13 where you have to repay some or all of the debt, as opposed to a Chapter 7 where you pay none of the unsecured debt? Well, there could be several reasons. Under the new bankruptcy legislation, which was enacted in 2005, there were income caps imposed, whereby, depending on how many members there were in a household, and that would be looked at in comparison to your income. And then if your income was too high, you might not qualify for a Chapter 7 and will be forced to file Chapter 13, where some or all of the debt must be repaid. Other instances of people choosing Chapter 13 over Chapter 7 is that there may be instances where there is, say, a home foreclosure happening, and the person wants to save their home from foreclosure. Well, a Chapter 7 doesn't have that ability because there is no repayment provision. Where Chapter 13, you repay debt to some extent or another, and so it is possible that a person who's losing their home in foreclosure because they're behind 6, 7, 10, 12 or more mortgage payments can be allowed, or will be allowed, to catch up on those missed mortgage payments, but spread them out over a 3 to 5 year period, and pay a little bit of it back every month, while at the same time keeping their current mortgage current. And the lender, under those circumstances, would have no choice. They will be prevented from foreclosing on you. They will have to accept the smaller payments through what we call a Chapter 13 repayment plan. And then the unsecured debt in a Chapter 13 would be handled differently. Only a percentage of that will be repaid. It could be as little as 5 cents on the dollar. It may be 100% repayment, depending on the income of the debtor and what their allowable living expenses are. And when you subtract the allowable living expenses from their income, what you have left is what we refer to as disposable income. The income above and beyond what you need to live. Home, mortgage, rent, gas, lights, food, clothing, etc. In a Chapter 7, which many people qualify for, again, 100% of the unsecured debt is eliminated. Now, secured debt, again, cars, houses, traditionally those two items. There can be other things as well. You cannot eliminate the debt and keep the collateral, which is to say, I can't eliminate my mortgage but keep my house, or eliminate the car payments but keep my car. What bankruptcy will allow you to do, though, is if you want to get rid of the mortgage or the car note, you must surrender the house or surrender the car. When you say, well, I don't want to lose my house and my car, that's okay. You don't have to, assuming that you're current on those bills, the car, the house. You can keep those items, but you must also keep the debt associated with it, because again, they're secured. The debt goes with the collateral. If you keep the collateral, you must keep the debt. If you get rid of the debt, you must get rid of the collateral. But again, unsecured debt, credit cards, hospital bills, etc., are completely wiped out in a Chapter 7, and can partially be wiped out in a Chapter 13. So that's sort of and there's more detail to it, but that's sort of an overview of the difference between Chapter 7 and Chapter 13. Now, other things that you should know about those two chapters. How long does the process take? How long from the time a client walks into my office until the debt is eliminated or restructured in the Chapter 13? How long does all this take? Well, in a typical Chapter 7 scenario, once the client has provided me all of the information that I require, we draft what is known as a bankruptcy petition. And that document is a pretty thick document. It contains just about everything about your financial life. Your income, your living expenses, information about all of your debt, including the debt you're going to keep or want to keep, and the debt that you want to get rid of. When that bankruptcy petition is filed with the bankruptcy court, we, that is myself and my client, attend what is known as a creditors meeting. In the Chapter 13 situation, it's two parts. It's a creditors meeting and what is called a confirmation hearing. That occurs about 30 days after the petition is filed. Once we attend that meeting, assuming that all goes well, and it usually does, we don't go back there anymore. In the Chapter 7 scenario, there is a waiting period of 60 days after the creditors meeting. That 60 days is to give creditors a certain time period to challenge what we call the discharge. That is, that the court grants you a discharge, eliminating all of the debt that can be eliminated under the law. That's a 60-day window. When that 60-day window is over, the court, assuming that everything else has been taken care of, all the other requirements have been met, will issue a discharge to the debtor in a Chapter 7. That entire window of time, 60 days for the waiting period, 30 days to wait for the creditors meeting, you're talking about somewhere between 90 plus days as far as the process time. In a Chapter 13, the period of time lasts significantly longer because there's a repayment portion to the Chapter 13, and the law says that any Chapter 13 repayment plan must last a minimum of 36 months, 3 years, but no more than 60 months, 5 years. So the debtor will not receive a discharge any sooner than 36 months, but no longer than 60 months. So that's a 3 to 5 year waiting period to be done with the Chapter 13 scenario. And again, because debt is being repaid back on a weekly, bi-weekly, monthly basis, however you're paid, and that money is going to what someone called a trustee, who oversees the bankruptcy and distributes those payments to your creditors. So in the Chapter 7 scenario, 90 plus days. In the Chapter 13 scenario, anywhere between 3 and 5 years. So that kind of gives you an overview or a sense of how long the process takes. Now when we come back next time, I'm going to go into a little bit more detail about the process and about what life is like after the bankruptcy process. Again, thank you for joining me. I am Attorney Nicholas Hicks, and I will see you next time.